Hello friends, in the series on the income tax cases, today we will discuss an issue on the assessment proceedings under section 153A. The basic rule of section 153A proceedings is that the addition under section 153A can be done only if the revenue has the incriminating material for that year for which the assessment is going to be made. The issue before the Kerala High Court in the present case was that whether the incriminating material for one assessment year which has been collected by the revenue during the search on the assessee can be used as a basis for making the addition for other assessment years which are covered by the search. This issue has been taken up by Honorable Kerala High Court in the case of Sunny Jacob Jewellers Gold Hypermarket versus Commissioner of Income Tax, and this case is reported in 473 ITR at page number 159, and the date of the judgment is 19th June 2024. The facts of the case are like this. In the present case, there was a search on the assessee on 21st August 2007 in which the incriminating material related to the assessment year 8-9 was only discovered. The period for assessment was covered for assessment year 2002-3 to assessment year 8-9, 6 plus 1 year. 1 year was of the year of search and the remaining back 6 years. During the assessment proceedings, the learned assessing officer, on the basis of the incriminating material for the assessment year 8-9, calculated the income of the assessee for the assessment year 2002-3 to assessment year 7-8 on the basis that the same 70% under statement of income for which the incriminating material was there for the assessment year 8-9 also applies to the remaining years. The plea of the assessee was that since there was no incriminating material for rest of the years, so the addition cannot be made in the hands of the assessee. The assessing officer calculated 70% suppression and applied same rate to all the assessees for all the assessment years on the basis of the incriminating material of the assessment year 8-9. The learned assessing officer also disbelieved the gross profit ratio of the assessee of 18% and increased it to 22% on the basis of incriminating material of assessment year 8-9 for all the assessment years and for all the assessees covered into the group search. The assessee moved to the CIT appeal. CIT appeal gave relief to the assessee on the basis that there was no incriminating material for the assessment year 2002-3 to assessment year 7-8. When this matter came to the tribunal remanded this matter to the assessing officer for re-adjudication, and in the second round of litigation also the assessing officer made the same additions on the same grounds, and even the CIT appeal in the second round of litigation gave relief to the assessee. The luck of the assessee was very hard, and in the second round of litigation, when the matter came to the tribunal upheld the order of the assessing officer and said that the additions for the assessment year for 2002-3 to assessment year 7-8 was valid, and hence the assessee has to go to the High Court. The High Court said that in the present case there was no denying the fact that the incriminating material was available only for the assessment year 2008-9, so the basis cannot be taken for making the addition for the other assessment years, that is the assessment year 2002-3 to assessment year 7-8. So the High Court gave relief to the assessee because in the present case the revenue do not have the incriminating material for rest of the years. The incriminating material was available only for the assessment year 8-9. So the same percentage and the same gross profit ratio cannot be applied for all the assessees and for all the assessment years. At the end of this video, once again, I am repeating the name of the case The name of the case is Sunny Jacob Jewelers Gold Hypermarket versus Commissioner of Income Tax, and this case is reported in 473 ITR at page number 159, and the matter has been decided by Honorable Kerala High Court on 19th June 2024. Thank you, friends.